Parents are considered the natural guardians of their minor children. But if something happens to both parents, then a guardian must be appointed to take care of your minor children. If you are married and you and your spouse are in an accident and both die in that accident, now your children have nobody to care for them, nobody to make legal decisions for them, and nobody to provide medical care for them without going to court and having someone appointed to be the guardians of those children. The steps for becoming a guardian of a minor child are the same as they are for becoming the guardian of an adult. But the person who is applying for guardianship over minor children must apply to the court, state that the parents have become deceased and that they are the best person to be the guardian of those children. A lot of times this can result in fights between family members. The grandparents may be the natural persons to want to be guardians of their child's child, but often there may be your siblings, there may be other people who believe they would be a better guardian of the children, and now you've got competing people stating that they should be the guardians of your children. That can draw out the process and create a lot of heartache for your family. When they're already grieving the loss of a loved one, they now are setting themselves up for fights and disputes over who should take care of the minor children. If there's a dispute over who should be the guardian of your minor children, the court is going to hear evidence. They're going to hear evidence from all of the people who are applying to be guardians for your children. They may hear evidence from other third parties who will have an opinion as to who should be the guardian of your children. The court will make the final decision as to who is the best person to take care of your children. Before a guardian is appointed for your children, the court may find it necessary to establish an emergency temporary guardianship and appoint someone to be the temporary guardian so that the kids have a place to live. The scary thing is that when something happens to you and your spouse, leaving minor children behind, in that emergency situation, your parents, your spouse's parents, other family members may be far away, and your children need someone to take care of them now. What can happen is that if no one knows who your family members are, or how to reach them, your children could end up in CPS or foster care while they are trying to find your family members to determine who should be appointed guardian. That's something you really don't want to happen. The best way to avoid the drama and delay of a guardianship for your minor children is to designate guardians ahead of time in your estate plan. Within your will, you can state who you want to be the guardian of your children if something, God forbid, happens to both you and your spouse. And you can designate multiple people to be guardians if for some reason the first choice is not available or not willing to be acting as the guardian for your children. If something happens, you can delegate to alternates. You can also designate guardians for minor children outside of your will. So if you do nothing else, even if you don't have a will in place, please, please, please designate guardians for your children. So in the event something terrible happened to you and your spouse, that the court would know who you want to be the guardian of your children, and the fighting can be avoided. If you're concerned about what would happen to your minor children if something were to happen to your spouse and you, please give us a call where we can discuss for you how to avoid guardianship in Texas.